there's gotta be some damages, right? You can't just, doesn't.
The guy says like, my insurance is gonna go through the roof, like, why would you, you know?
Yeah, we had stories like that also. Lots of stories, lots of stories.
Beautiful story. I was in your neck of the woods.
That's what
It happened to go too far north of Clark.
Okay,
So I can see.
so in the final analysis, just to review where we were,
Let's see.
you can't hold someone liable if they drop their fingernails or toenails in public and a pregnant woman steps on it and miscarries. There's two reasons. Number one, for hezek that is based on supernatural phenomena, you can't collect damages on. That's number one. And number two, and that's something that's debated in the poskim. And number two, you can't prove that it was my toenails that caused her to miscarry. There may have been other factors than my smelly toenails.
Like, do you think I don't think even accept it as a case? Isn't that a little bizarre?
I don't know. I don't know. It's an interesting question, but it's certainly something you'd never hear in Ontario Superior Court.
So.
Yeah. Okay.
Tomorrow we'll go.
Yeah, Bar's gonna
We're
send
gonna
us
what's
up.
up.
Guy sues for toenail.
I think the lawyer will be put in that mental.
Okay, let's start the next tshuva. All right. Mi shechatam ve'achar kach ta'an shelo hevin al mechatam. Okay, this is getting into Marvin's territory. A guy signs a contract and then later claims that he's not bound to the contract because he didn't understand what he was signing on. Okay. Classic, huh?
Yeah, it's called non-S factum, which means it isn't my signature. Somebody afterwards says, I never signed, I signed it, but I didn't understand, it's, or whatever. And the law is that if there's any degree of negligence or fault, you had the opportunity to ask, you had the opportunity to get advice, you could have read it, all that, you signed it anyway, too bad. So that defense does not apply when there's your own negligence. So
Non-S factum.
non-S factum, N-O-N, then E-S-T, and F-A-C-T-U-M. It isn't my signature. It's a classic defense, but it will fail if you're at fault yourself for carelessness.
Okay.
Independent legal advice.
If you had the opportunity, and many contracts say they were given the opportunity, whatever, but the fact is if you rush through it or you did a click thing online or whatever it is, and you just simply you could have taken the opportunity to read it, then the whole defense falls. You don't have it. But if everything else is fine, and there's somehow some, whatever, there's different.
Give us an example of a situation where a guy could prevail in a claim of non-est factum.
Okay, so let's assume he mistakenly thought, this gets into the area of mistake, which is very close to it as well. There's your own unilateral mistake, and then there's common mistake. But the two are kind of connected, but one example might be where you thought it was, you're a busy guy or whatever it is, you were negligent, but you thought that this had transferred this to your wife, but it transferred it to some stranger. Weren't careless, but it didn't get to the point of being careless. It got to the point where it was something that a reasonable person might have overlooked at the time. You didn't appreciate something because you read it, but it was too technically whatever. Sometimes the court will give you relief because you sort of say, seems fair in the circumstance that, you can get out. It's kind of a rare thing.
About perceived coercion.
That's a different thing. So there's other reasons to invalidate a contract, like you have, the basic ones are duress, where someone forces you down at the head, or economic duress, unconscionability. The contract is just wild. Like, like 2 weeks ago was where there was an arbitration clause in there that said you have to just arbitrate this dispute. It had to do with software or something in China. and you have to use the courts in China to, it's like a $3,000 dispute. They're forcing you with the arbitration clause to go to China, fly there and go to court to deal with that, which no one reasonably would. So non-est factum wouldn't work, but unconscionability would. The court says this is just like totally whacked out, right? It's just like totally unfair. Yeah, it's in there, you knew it was in there, and now you want to apply it, it makes the whole agreement null and void. So there's duress, unconscionability, undue influence. So, let's say your parents or somebody are, 19 and someone forces you to sign something or marry someone or whatever. That's duress, and then unconscionability, mistake, sometimes common mistake, sometimes individual mistakes, and what else? I think that's about it. There's like 5 or 6 categories that would invalidate a contract.
Okay, thank you, Marv. So let's see. Ani me'unyan l'shapetz et dirati u'lohotzi mirpeset. I'm interested in doing some renovation work on my apartment and to expand my mirpeset. Okay. Uletzorech kach hechtamti et shcheni al hatochniot shal yedei chatimato hu me'asher li l'shapetz u'lohotzi mirpeset. And so I got my neighbor to sign off on it, on the plans, that through his signature, he gives me permission to expand my mirpeset. And now my neighbor is complaining that he doesn't agree to expand my mirpeset. I guess maybe it may obstruct him in some way, or it may obstruct his view, or something like that. So he is not agreeing to my expanding of the mirpeset. He just is allowing me to renovate it and to improve it. Because if I'm going to expand my mirpeset, it's going to prevent him from building his sukkah. Oh, he must be on the floor below me. Okay. And the reason why he so readily signed, he claims, is because he didn't carefully read the plans. Okay? And now he's prepared to bring the other neighbor to testify that he clearly didn't understand. Does he have a valid claim? Okay, so Marv, what do you say?
Okay, I say he doesn't have defense. He had the opportunity, he didn't take it out, whatever, and it's his fault.
Signed off on the plans? Okay. Ba-bum-bum. People's Court. Let's see. Ba-bum-bum. No, that was Judge Wapner. Don't you remember Judge Wapner?
Yeah, sure.
Okay. So tshuva. Reshit kol niten aleinu livarer she'ein la'ed hanal shum negia badavar. So first of all, let's make sure that the witness that your neighbor is prepared to bring to Beis Din is not nogea badavar. He doesn't have a personal stake in this matter. Maybe he also doesn't want there to be an expanded balcony. Ki kol eid sheyesh lo afilu tzad rachok shel negia b'davar harehu pasul le'idut ba'oto din. He says, because any witness who even has a distant aspect of bias or has some conflict of interest, harehu pasul le'idus ba'oto, then he would not be allowed to even testify. So, in other words, this neighbor who's lodging the complaint is, oh, my neighbor also knows that I didn't know what I was signing. He'll testify. Well, maybe he's testifying because he also doesn't want my balcony expansion. As the Shulchan Aruch writes, Devarim elu tluyim b'da'as hadayan va'otzem binato. These matters are dependent upon the attitude of the judge, in other words, his estimation. Sheyavin ikar hamishpatim v'yeda davar hagorem ledavar acher. The judge, this is, I guess, all laws of Dayanos. The judge has to carefully discern and examine what causative things are involved in this whole case. And he has to really explore very carefully if the witness that is testifying has any personal stake, has any personal interest in this case. And even if it's a distant personal interest, but it's a personal interest nonetheless, he may not testify. Laws like this exist in the courts here. Can a witness be eliminated because he has a personal interest?
It used to be, but not anymore. So prejudice, bias, interest, all that stuff does not make you incompetent as a witness, but it will affect your credibility. So it's up to the judge to hear the testimony. You're allowed to testify. But then, cross-examination will bring out that you have an interest in bias or prejudice, and the court will probably give it no weight. Right?
So here in Allah, it's different because once you hear the testimony, it may actually change the date. So halacha is different. There are sometimes when we will disqualify a witness and won't even allow him to testify in base there.
The three classic ones were in the old days, the wife and husband couldn't testify against each other. That has been eliminated by legislation, and also if you had a criminal.
I mean, like in divorce court?
In any court. You couldn't do it. So if you had a criminal record, somebody has a criminal record, they were invalidated from testifying. If that's been changed by legislation too.
So that I understand, because people can do tshuva. But if a person has an active personal interest,
It's the same thing by a jury too, they invalidate jurists.
Yeah,
Because.
that's right,
But
right.
the adversarial system, the idea is the truth will come out with two cross-examination.
Let's just put everything out
Put
there.
it out there, let
Yeah.
the truth come out,
Okay.
and it's up to you to bring it out.
Right. So that's an important distinction. Okay. Now, v'humi lashon harambam, and this is all based on the Rambam. V'mitbarer l'dayan she'ein lo shum negia efshel lekabel eduto. Now, if the judge is able to verify that this neighbor couldn't care less and he has no personal interest because other people in the building have also expanded their mirpesets without any objection and so forth and so on. So then you can accept his testimony. Aval im yera'eh l'dayan sheyesh lo eze negia afilu b'derech rechoka ein lekabel eduto. But if it appears to the judge that there is some kind of personal interest for this witness to testify, even if it's quite distant, you may not accept his testimony. Base, that's number one. Number two, me'achar v'hashachein chatav al hatochniot v'chatam b'feirush shemosifim mirpeset me'al hamirpeset shelo. The fact that the neighbor signed on the plans, and it says explicitly in the plans that they're going to expand the balcony, eino neman lomar lo hevanti al machatamti. He's not believed if he says, I didn't know what I was signing on. As the Shulchan Aruch explicitly states, Hoda'a bichtam yado v'hashtar begufan shel goyim, that if there's an admission that this is his signature, and the shtar is begufan shel goyim, I'm not sure what that means. I think it means that I think it means that the body of the contract is in conformity to what the Gentile laws are. V'hadavar barur she'eino yodea likrot, and it's clear that the person who signed doesn't understand the language. Okay, v'yesh edim shechatam eid shelo kira'o. Oh, I see what it is. In other words, let's say a guy admits that he signed to a contract, but it's in a foreign language, and it's clear that he can't read it. However, the yesh edim shechasam ad shelo kira'o, but the witnesses say that he signed it nonetheless without reading it. Mikol makom mitchayevu b'chol ma shekasva bo, but he still is liable. If you sign on a contract, even though you don't know what it says, you're still going to be liable according to the Shulchan Aruch. Va'ayin bismasham shehisbir betuv tam v'das she'ein shom makom sheba'olam liftor oto michiyuvo ve'olav lechabed et chatimato. And the Sma says explicitly, there is no basis with which to say that I can exempt myself because I didn't know what I was signing on, and he has to honor his signature. So even if it's in a foreign language, like let's say, you're buying a property in Israel and everything's in Hebrew, and you get the lawyer to explain it to you, and he goes through it with you, but you don't know the Hebrew, you still have to abide by the law, right? Pasak HaShulchan Aruch Mishatan al Ketovet Ishto Shahaya Am Haaretz Velo Haven Kishakara Chazan Haktuva Vatanoim Ein Shomin Lo. Let's say a woman and a man are getting divorced, and the guy claims, well, I shouldn't have to pay my wife's ksuva because I didn't know what I was signing on. I didn't know what I was committing myself to when we got married, because I don't understand Aramaic, and I didn't, and whatever conditions are stipulated in the ketubah. So that's not a valid claim. And that's probably true about most people who have a Jewish wedding. They don't understand. Now the rabbi should explain it to them. That's what I do when I'm a Sadr Kiddushin. I carefully explain to the groom that you're making a financial commitment that is collectible at the termination of the marriage, either from you personally or from your estate, if you predecease your wife. However, but they usually don't care.
You got other things on the mind.
That's right.
There's the eating on the table is not valid.
That's a separate issue. You're right, though. But if the Edom are not valid witnesses, then it's not a legally binding document. And I've had that case too, where I told you that story, right? Where the Chassan tried to pass off two of his college buddies as Shomer Shabbos.
Yeah, but that's something else. That's not invalid. That's not understanding what's written there. That's just the Edom have to be Shomer
That,
Shabbos.
right. The Edom weren't kosher. But if the Edom are kosher and a guy commits himself to the terms of the ksuva, in Eretz Yisrael, they have the chassan sign it. Here, our minhag is just to have him make a kinyan. Either way, he's committed himself in front of witnesses to the terms of the ksuva, and it's legally binding upon him. And therefore, you don't listen to him. V'hosif harama hu hadin b'sha'ar dikdukim sheyesh l'daktek min hashtar. That the same thing is true with other specifics having to do with contract law. If it was written in a foreign language, before signing it, he should have said, I don't understand what is written here. Translate it for me, va'eda, and so that I can know what I'm signing on. The fact that he didn't say that, that anytime he is silent and just goes ahead and signs it without asking for translation or an explanation, that's a Kabbalah. That's an acceptance. It's a tacit acceptance. That he accepts upon himself all of the details of what is the standard contracts contain. Okay, and so he says. So it's interesting because he writes in the Makor Baruch, he says, V'yesh ledaktek, he says, we have to really think about this for a moment. Damai dinzen nifsak b'shulchan aruch pamayim kanal. Why is this halacha paskened twice in the Shulchan Aruch? Echad b'simin memhei v'chein b'simin samach aleph. Rav Shrager just quoted from two different simanim, two different chapters in the Shulchan Aruch, one in chapter 45 and one in chapter 61. So because of a Pischei Tshuva b'shem Chasam Sofer v'zel Lashona, he says, so the Pischei Tshuva quoting the Chasam Sofer says as follows: Diyesh chiluk din bein masher kasav kan l'masher kasav b'simin memhei. The sham b'simin memhei d'mayr shuhu atzmo chasam. He says in the earlier siman, the halacha is addressing a person who signs himself the contract. Azai kol masher kasav b'shtar utzalamar afilu dvarim tzdadim she'eno meikar guf toichen hashtar afilu asas adeu meitzer la'acher hakol bichlal ne'emanim lishlish. He says, since you in that case you sign on your own, even if there are additional addenda in the shtar that are not addressing the main point of the shtar, so then even afilu asa sadehu meitzer la'acher, in that case, it's a real estate deal. So even if you, through the signing of this contract, you made your, I guess you gave up your rights of a certain border of property, and you allow someone else to buy a property that's right up to your property line, when maybe you argue later, I wanted first rights of refusal to purchase that property. And let's say you give up that right by signing this contract, hakol bichlal ne'emanim l'shlish. But everything is included in this halacha that the shtar is legally binding. He says that in the later chapter, it's talking about where the person himself is not signing, but witnesses are signing that he enacted a kinyan. That's like the case of the ketubah. In Cain, dafka guf ha'inyan sha'idim me'idim alav. He says then it only applies to the part that the witnesses sign on. Aval asa'u meitzer la'acher ein habaldin mafsid al yidei edutam ad kan devarav va'ayin sham od mashakasav bazeh. He says then it's only the things that the witnesses sign on it, which pertains to the body of the contract, and not any addenda which are added on later. And so I'm not really sure if I fully understand this distinction that he's writing. So we would have to go into further analysis over here. But the bottom line is that a person, whether he signs himself or whether he just makes a kinyan and witnesses sign it, in either case, he's bound to the terms of the contract. V'yotze midivri maran sham, shafilu im hayu shnei edim kesherim, shemeidim shelo yada al machatam, lo to'il edutam kiklipat hasham. He says, but what emerges is that even if witnesses testify, this guy had no idea what he was committing himself to when he made the kinyan on the ketubah. It doesn't make what's that term that they use? It doesn't make a difference at all. He uses the idiom in Hebrew that it doesn't even make a garlic skin difference. In other words, it doesn't even make a tiny difference. It makes absolutely no difference whatsoever. Kemavur b'tshuvas haramban b'din shtar shenichtav b'chtav shel goyim v'hu lo meivin afilu mila echad v'hu chatam aleha. The Ramban has a specific and explicit tshuva on this matter. A person signs a contract in a foreign language. He doesn't understand a word of it, but he signs nonetheless. V'afilu yesh edim shechatam ad shelo kira'o, and witnesses testify that he signed this before reading it. Mitchayevu ata b'chol masha kasuv bo. He still is obligated to abide by the terms of the contract. Keven shelo chashash likroto v'somech al hasofer. So because he didn't take the time to read it and he relied instead on the scribe. Mikol makom kol hasomech al ne'emanim acherim halohu gomer b'daito li'itchayev b'chol masha kasuv bo. Nonetheless, we assess a person's thinking that he's committing himself to whatever is written there. Kevin shelo chashash likroto v'somach ala sofer, because he didn't bother reading it and he relied instead on the scribe. Alohu gomer b'daito li'itchayev b'chol masha yomar. So he's indebted himself. He's obligated himself to abide by the terms of the contract. The chen kasav hakneses hagdola kishu atzma chosem mechayvin oto shechazaka hu delo chasam aid. Ad diadia mai deichtav alei. Same thing Knesset Hagdola says. We assume that a person is not going to sign until he knows what he's committing himself to. Or he says, listen, I don't care what the details are. I'm fine with it, and I'll commit myself to whatever the terms are. A lot of times, let's say, for example, you go to an amusement park, like go-karts or whatever it is, and they'll make you sign a waiver, right? So that's also an example of this kind of situation where if you don't read it correctly, You know, you have to, there was a time, I remember one day, one of my children came home and asked me to sign this waiver. The class was going on go-karting or whatever it was. And you basically signed away any and all rights, including acts of negligence on behalf of the company. In other words, I think it said explicitly, even if the company is negligent, then you hereby sign a waiver that you will not litigate against them.
Engrossing it.
Right, or gross negligence, which is crazy.
Yeah.
How, and people are expected to sign that?
Your kid didn't talk to you for a month because you didn't sign it.
And I said, I can't sign this. This is ridiculous. I don't even remember how we resolved it. I think maybe my wife signed it.
There are lots of cases.
But it doesn't make sense to me.
Sports things, ski hills, go-karts, paragliding, there are all these things that are the widest possible you can probably get, is, you know, in favor of the company. But the litigation is, yeah, you may have said, I'm waiving you from negligence, but you didn't say gross negligence, right? So that wasn't covered and you were grossly negligent, that's how they get them. They say it didn't fit within your language, right? Because it's your.
Well, so what if it says in the contract, gross
Yeah,
negligence?
then you're probably done.
Imagine going to a baseball game or a hockey game, you have to, like, as part of
Yeah, all
the
that
thing,
stuff.
you get a
Yeah.
puck in the head
Yeah.
or a ball in the head, you're taking it. You
So
can't
look at it as
sue.
a matter of contract, and then they say, what does the contract say? Was the contract valid? Yes, yeah, okay, yes. And is the scope of the language wide enough and interpreted reasonably enough to cover the event that happened? If the answer is yes, then you're probably done.
What happens when someone will back in the ticket?
Well, then it has to be brought to your attention. It's like, if it's too, like also click wraps and stuff where all these things are set out before you even get a chance to click. You've already agreed. A lot of that is, well, you didn't have an opportunity to agree before you agreed to it. Maybe you can get out of it then. But that's why, I know we were just in Harrisburg and we went to a indoor play thing with the trampolines for the kids. Took us 15 minutes to fill out all the forms, and then even the baby had to name the baby, that you're releasing even liability to the baby, because someone might run into them in the thing. It was like the craziest thing, or you didn't want to sign it, but whatever, we signed it. But yeah, it's like crazy stuff. But no ticky, no entry, right? So
Yeah, so they sort of have you,
they have you can't even get in, you have to present online, the stuff before you pay, right? So they won't even let you into the place until you sign all of that. So we signed it. Well,
you've already paid in advance.
paid, you haven't paid, but they have a kiosk where you fill out all these forms online and then sign it, and then you print it, sign it, take it up, and then you pay, and then they let you in. So, yeah, but that's the states, right? They're like so litigious also, so.
Well, here too, I found the waiver form that I had to sign here was much more explicit than anything I'd ever done.
For what?
For one of these go-kart things or whatever.
Right.
Yeah,
There are cases also where you sign on behalf of your minor children. And then there's a famous case where a minor child did get injured. And then you'd think, okay, they can't sue, and when they become the age of majority and they got seriously injured, where they became the age of majority, they sued, and they sued their parent for waiving their rights when they were a minor, and they
Yeah.
won.
They what?
Yeah,
Yeah.
because it was one of these crazy waivers that, that had, why would you ever release, if I was like old enough to do it myself, I would never release them from this kind of crazy stuff, like.
right.
And so it was upheld and said you had no right to waive it on behalf of your kid at that time, because it was a crazy.
Yeah,
waiver.
but the courts, who did they find liable to pay? Like,
The
Parents had to pay their kid?
The parents, yeah, they sued the parents and I don't know, whatever it was, but somehow they figured it
Oh
out.
my God.
wow.
Crazy.
Okay, bottom line is, we'll finish this tshuva tomorrow, but Rav Shraga is basically going in the direction of a guy can't get out of it, even if the witness is a reliable witness that the guy
So
didn't
if
understand.
This is about a sukkah, now he has a mitzvah derice that he can't perform, does that have anything to do with it?
No, because you're able to perform the mitzvah, you just have to do it downstairs in the
Or you go to
communal
the park
sukkah.